Partner of Lopes and the Secretary of State for the Home Department.
Yes, good morning.
May it please the Court, I appear on behalf of the appellant, and my learned friend, Mr. Watson of Queen's Counsel, appears on behalf of the respondents.
Before you start, can I just ask you whether you've, how you'd prefer to be addressed? Because some people really mind. Ms., Mrs., Miss?
Miss Lanigan.
Miss. Okay, lovely. Thank you.
I'm grateful, my lady. To start with the housekeeping matters, could I just check that your lordships have all of the bundles? There should be a core bundle, a supplementary bundle, and an authorities bundle.
Yeah.
I'm grateful. There are some additional documents to hand up. From my side, there is a replacement appeal skeleton argument with updated bundle references, which was sent through to the court yesterday, and I hope that has reached you, but I do have printed copies.
I think we've all received copies of that.
The other two documents that I would seek to hand up, if it would assist, are the authorities at tabs 1 and 2. My learned friend and I have discovered that the authorities seem to have pages missing for some reason, and I have the complete cases to hand up if that would assist.
That would be helpful. Thank you.
Is that the case in the electronic version as well?
It seems to be so. Yes, I apologise, my lord.
Very much.
Thank you.
You can take it that we've read the skeletons and the core documents, so you can take the backgrounds relatively quickly. That's all right.
I'm grateful, my lady. In terms of timetable, I seek to address you on the grounds of appeal and the habeas corpus issue, followed by my learned friend. And having discussed timings, it seems that we hope to be finished by lunchtime,
right.
If not shortly afterwards.
All right, that's very helpful, thank you. And thank you for discussing it in advance.
Thank you. My lady, my lords, you will have seen the grounds of the judicial review, which are set out at page 45 of the core bundle,
yeah,
as well as the application for habeas corpus, which is at page 63 of the core bundle. And you'll also have seen the judgment of Mr. Justice Baker in the court below, refusing permission and dismissing the application, and his judgment is at page 42 of the core bundle.
yeah.
There are 3 grounds of appeal. First, that the learned judge is wrong as a matter of law in his assessment that the appellant is not eligible for removal.
Now, when you say not eligible for removal, what do you mean?
In terms of the scope of the tariff expired removal scheme,
Right.
which goes hand in hand with the provisions that apply for deportation of foreign criminals from this country.
Yes, because the starting point is the statutory provisions.
Indeed, my lady.
Yeah. All right.
The second ground is that the learned judge erred in his assessment that the parole board review was a key to unlock the puzzle, to use his phrase.
Mm-hmm.
And finally, in light of those 2 grounds, the learned judge did not properly consider the arbitrariness of the appellant's ongoing detention.
All right.
Unless Maybe would like me to address a particular ground first. I'll take it in that order.
No, do please.
Okay. So starting then, the first ground of appeal is set out at paragraphs 61 to 66 of my replacement skeleton argument, which is at page 127 of the core bundle. Yeah. I submit that Mr. Justice Baker, respectively, was wrong in his conclusion that the appellant is ineligible for removal. Now, it is correct, and I don't seek to contest the application of Section 12, subsection 3A of the Extradition Act 1989. Under that statutory provision, the appellant cannot be extradited to Portugal since he is serving a sentence.
Yeah.
And that will, of course, continue to be so until the parole board deem him eligible for release.
Yeah.
The key flaw in my submission, in the decision of Mr. Justice Baker, is the conclusion that due to the extant extradition request, this renders the appellant in deportation terms ineligible for removal and a prisoner to whom the scheme simply does not apply. Respectfully, that conclusion is wrong, and I seek to take you through the statutory provisions as well as what I say is the correct reading of the policy itself, and finally to touch on the case law. And I say that all of those point towards the appellant being removable. So turning then first to the statutory provisions, which is set out in section 32A of the Crime Sentences Act, which is at page 103 of the supplementary bundle. The Secretary of State has the discretion, under subsection 1, to remove the appellant if three conditions are met. First, if he is a life prisoner in respect of whom a minimum term order has been made. Second, if he is liable to removal from the United Kingdom. And finally, if he has served the relevant part of his sentence, that being his minimum tariff.
Yep.
I will take the first and third conditions because they can be dealt with briefly.
Well, I don't think there's any dispute that those two conditions are met, is there? No.
I'll move to the second condition then. Whether he is liable to removal from the United Kingdom. As set out at the very bottom section of that page, subsection 5 states that liable to removal from the United Kingdom has the meaning given to it by section 259 of the Criminal Justice Act 2003. That's at page 75 of the supplementary bundle.
Yeah.
And specifically under subsection A, he is liable to deportation. In order to be liable to removal from the United Kingdom, he must be liable to deportation under section 3, subsection 5 of the Immigration Act 1971 and have been notified of a decision to make a deportation order against him. Now, I'll take that second limb first because I can deal with it more briefly.
Yeah.
That notice of a decision to deport was served on him in late 2017, September, October 2017.
Yeah.
And indeed, the appellant signed a disclaimer stating that he did not seek to raise any objections in relation to his deportation. So quite simply, that second limb is satisfied.
Okay.
So the question then turns on that first limb, whether he is liable to deportation under Section 3, subsection 5 of the Immigration Act 1971. This is set out at page 93 of the supplementary bundle. And I apologise for moving between the pages, but it seems important to take you to the relevant provisions.
No, it's essential.
Oh, great. Subsection 5 is towards the bottom of the page. And I say, bearing those provisions in mind, the appellant is quite plainly liable to deportation. He is not a British citizen. He has been convicted of an offence and sentenced to a period of at least 12 months. Therefore, he is a foreign criminal and his deportation is considered as a matter of statute to be conducive to the public good. That is applying Section 3, subsection 5 of the Immigration Act 1971 and Section 32 of the UK Borders Act 2007, which is over the page at page 95 of the supplementary bundle. Specifically, Section 32, subsection 4, which states, for the purposes of Section 3, subsection 5a, the deportation of a foreign criminal is conducive to the public good. Now, I would invite your ladyship, your lordships, to give particular attention to the fact that the appellant's removal as a matter of statute is considered conducive to the public good. And that is regardless of whether there are extant extradition proceedings. That is set out in the provisions under Section 33 of the UK Borders Act, which is again over the page at page 97 to 98 of the supplementary bundle.
Forgive me, sorry, Ms. Laing. Which bit of Section 33 am I looking at?
Specifically, my lord, Section 33, subsection 7. Section 33 provides the exceptions to automatic deportation under the UK Borders Act, and Section 33, subsection 7 sets out that even where an exception applies, and the relevant exception in this case would be exception 4, which is found at Section 33, subsection 5, at the bottom of page 97. The statutory provision regarding whether or not the removal is conducive to the public good, that still stands. As it states, Section 32, subsection 4 applies despite the application of exception 4.
So in other words, subsection 7b is making a general rule that there's no presumption about whether or not deportation is conducive to the public good unless exception 1 or exception 4 applies. Is that it?
Indeed, my lady, in which case it still stands.
Okay.
Forgive me, Ms. Lanigan, what do you mean by it still stands?
The Section 32, subsection 4 provision that states deportation is conducive to the public good in the appellant circumstances.
I see. Thank you.
Rewind to section 3, subsection 5.
Yes, my lord.
Or maybe I need to rewind further. I think we're going back to section 259 of the Criminal Justice Act. Yeah. You told us that there'd been an order decision to deport him.
There was a notice of decision to deport.
Yeah. Well, can I just remind me when that was?
October 2017,
It was
I think you said?
September, October 2017. If my learned friend has a specific date with which to assist the court, I'm sure he'll...
30th of September.
I'm grateful.
So the position is that notice of intention to make a deportation order was served on the appellant, but no deportation order has been made. Is that it?
Indeed, my lady.
Okay, thank you.
The progress towards deportation somewhat stopped short after that point.
Okay. All right.
My lady, my lords, having taken you through those statutes...
Sorry to interrupt. I don't think I picked this up. So when I was doing my pre-reading, so section 259, which is the definition of liable to removal, refers expressly not to the making of a deportation order, but to notification of a decision to make a deportation order.
That's correct.
Yeah, okay, thank you. All right, thank you very much.
I say that in light of these statutory provisions, when properly analysed, there remains discretion for the Secretary of State to deport the appellant, and that discretion is specifically preserved, notwithstanding the extant extradition proceedings. Now, of course, it is a matter for the Secretary of State to adopt any policy it sees fit as to how that discretion should be exercised,
Yeah,
so long as it is a lawful exercise of discretion.
yeah.
If the policy adopted involved a blanket refusal to deport individuals subject to extant extradition proceedings, that, in my submission, would be unlawful, as it would be a fettering of the discretion specifically preserved by statute. And it's important in my submission to bear that in mind, and that is the lens through which the tariff expired removal scheme should be considered. Turning then to the specific policy documents, the first TERS policy document is at page 39 of the supplementary bundle, which is the original document introduced in 2012 and expired in 2016. And the updated policy document published in 2017 is at page 61 of the supplementary bundle. Now, there are two aspects to this removal scheme. The first is that a relevant prisoner must be considered suitable for removal, which is in accordance with the Suitability Criteria, which your Ladyship, Lordships will find at page 65 of the supplementary bundle. And there are 5 bullet points set out there. So the suitability criteria forms the first aspect. The second aspect is that a prisoner must actually be able to be removed from the country. And I'll call that removability. So to address you first on the issue of unsuitability, as I said, the criteria for unsuitability are set out at the very bottom of page 65 of the supplementary bundle. And these are presented as exhaustive criteria. There are no other criteria to be considered. It's simply set out as these 5 bullet points. And of course, it is notable that extradition proceedings are not expressly stated as being a criteria for unsuitability. Now, my learned friend submits that the appellant's case falls within the 5th criterion. That is, to allow the removal of the individual from prison would undermine public confidence in the criminal justice system.
Is there? I haven't seen any document in the bundle that explain. I mean, I just haven't seen any documents in the bundle that explain the decision-making process in this case.
No, my lady.
Why is that?
There's been correspondence via emails.
I mean, I've seen reference to several documents in the acknowledgement of service and the grounds in the claim form, but I'm slightly puzzled by the fact that there don't seem to be any documents, original documents in the bundle at all.
No, my lady.
So, how is one in a position to infer why it was decided that the tariff shouldn't be applied to the appellant if there isn't any relevant document explaining it?
Well, my lady, I accept that you don't have the original correspondence. The statements and the decision made rests on a few, what I would say, are cursory remarks from the respondent's agents, simply stating there are extradition proceedings and therefore you cannot be removed.
I mean, is there any reliance? I suppose the point I'm getting at is there any reliance in the decision documents on the 5th bullet point?
No.
Right.
And that is the first and key reason that I say that the appellant does not fall within the final bullet point. Because
whether the appellant does or doesn't, if it wasn't relied on at the time, how are we supposed to infer that that's why the TERS wasn't applied to him? I mean, it's really a question for Mr. Watson, not for you.
My lady, it is. I think it might assist for the court to see the response to the pre-action letter that was in the core bundle that was part of the original claim form.
Right.
When I saw that it wasn't in the bundle, I anticipated that there might be a question as to, well, where's the decision located?
Yes.
And so I've made copies. Can I just...
Has Miss Lanning-
My learned friend would have seen all this before. This is the May letter that explains...
But this is a
decision
this is a response to a pre-action protocol letter. It's not a contemporaneous document.
It isn't, my lady, but it's not inconsistent with the approach that was set out in the correspondence that's in the core bundle.
All right. Thank you very much.
The challenge was to a continuing refusal to deport, wasn't it? Not a particular dated decision.
that's correct. It's the ongoing refusal to consider him for the scheme.
read that. Okay.
So, quite simply, my lady, my lords, the appellant has not been deemed unsuitable in terms of the unsuitability criteria. The issue is removability. And it has been stated that extradition is a barrier to removal. I have further points to make in terms of why I say the appellant does not fall within that final unsuitability criterion.
Yeah.
But I can do so if that would assist the court. But it seems that...
Well, yes, we might as well hear from you on that, please.
I will do, madam, my lady.
I don't mind.
The second reason that his removal does not fall within that final criterion is that, in my submission, the purpose of his sentence has been carried out. He has served his minimum tariff, and he is now roughly 2 years and 9 months post-tariff. And it is noteworthy that during his 17.5 years in prison, the appellant has been something of a model prisoner.
So, did you say, what's the submission that he's served?
He has served his time.
But it's a minimum term.
Indeed, my lord.
It's a life sentence.
Indeed, and he has served the minimum tariff, and throughout that time, he has done his time. He has been punished. He has been a model prisoner, and I'll be taking the court to the parole board decision later on. But you'll have seen from that that he is a very well-behaved prisoner who is liked by staff in the wing. So in terms of confidence in the criminal justice system, in terms of ensuring that there is punishment and an individual...
But another way would be that the public would be less likely to have confidence in a criminal justice system that releases people who are considered by the parole board to be dangerous and who are subject to a life sentence.
That is a point, my lord, and undoubtedly an important one. But in my submission, the release of the appellant is distinct to what in this case would be removal. He would not be at liberty in the public. He would be detained and removed. And that is a crucial distinction in my submission.
But he'd be at liberty in Guinea Bissau, and he'd be a person whom the parole board consider is dangerous.
My lady, yes, I think I'm bound to accept that. However, one in my submission must look at the overarching circumstances of this case. The issue does not simply stop short at the appellant's removal. It's the consequences of that removal that are significant in my submission. And I say that because, somewhat paradoxically, his removal to Guinea Bissau, in my submission, would make it more likely that he would then stand charged for the outstanding allegations in Portugal.
Well, I don't think we're in a position to speculate about it, are we?
My lady, one can speculate insofar as considering what is a likely result of the circumstances in which he finds himself. And currently, there is this logjam, this catch-22, whereby the outstanding allegations serve to feature heavily in his risk assessment by the parole board.
They aren't the only thing in the risk assessment, though, are they?
No, they're not, but they are the key factor in my submission.
I'm not sure sure I read the decision of the parole board in that way. So your submission is the parole
perhaps it
board
would
treated them as a key factor.
if it would assist, my lady, if we could go to the
Perhaps we should.
parole board decision,
Yes, please.
which is at page 105 of the core bundle. And I would invite you to focus your attention specifically on page 109 under section 6, the panel's assessment of current risk. There it is stated that the appellant was assessed as posing a high risk of serious harm to the public and a medium risk to a known adult and children. And the risk to the public arises out of the outstanding allegations in Portugal for robbery, and the risk to the partner arises out of the index offence.
Well, that's the assessment of Mr. Ralph, the community offender manager.
Yes, my lord, and
which they endorse, but it's not the only evidence on the topic that they have seen and accepted.
I don't seek to say that that is the only element of risk, but quite plainly that is the key factor. You'll note, my lord, in the following paragraphs that there are, as you say, are other elements of risk identified, but in the third paragraph of that section, it states that there is a low likelihood of violent reoffending. And so, in my submission, the other risk factors are to be considered as lesser compared to the key aspects, which are these allegations in Portugal, where there is a high risk of serious harm.
But, I mean, I don't know what the acronym SARA stands for, but that's said to indicate a high likelihood of violence in intimate relationships. And Mr. Ray, the prison offender manager, considered that the appellant continued to pose an imminent risk to future partners. So that's clearly part of it, isn't it?
Yes, my lady, it is part of it, but it is not the key part in my submission.
It seems unlikely that Mr. Ralph or indeed the panel considered the mere existence of allegations in Portugal or about what he did in Portugal in 1999 to justify these conclusions. Presumably, we don't see it on the face of the reasoning here, but presumably there's some sort of analysis of the facts of the offending and the degree and the evidence supporting the allegation. And we know what the allegations were from the respondents' paperwork, but it struck me when reading this that if it was a decision based purely on the existence of allegations of that nature, then you might be suing the parole board, not the respondents in this case. Presumably that's not your view of what's going on, and that they've looked at the thing in rather more detail.
And the other thing is that the section 5, which begins on page 107, is a detailed account of the history and explains that the appellant hadn't done any offender behaviour work during his sentence because he'd been assessed as unsuitable because he was maintaining his innocence. But it goes on to say that there are now programmes available for those who deny their offences. All witnesses consider that risk could be reduced through you completing the motivation engagement programme. And it then goes on to say that Mr. Ray discussed one of the programmes with him and he'd been completely resistant. So I'm not sure it's right to read the decision of the parole board as being exclusively or mainly focused on the outstanding allegations, and I think that's clear from the conclusion. It says, whilst your tariff is expired and your prison conduct is good, this is section 8, you have not completed any risk reduction work. Panel accepts your continued denials are not an indicator of future risk. Panel does not have any evidence to indicate your risks have lowered during your sentence, other than by the deterrent effect of the sentence. So it seems pretty clear that one of the factors, a significant factor, is that he hasn't done any risk reduction work.
My lady, yes, but in my submission, it's not open to him to properly reduce his risk in respect of the Portuguese allegations.
But the decision's incoherent, if that's right, because the decision places considerable emphasis on the lack of the availability of risk reduction work and the fact he hasn't done it.
My lady, that in my submission refers to the index offence, rather than the Portuguese allegations.
Yes, but it would be pointless saying, well, we want you to do risk reduction work in relation to the index offence if that was incapable of reducing the overall risk. Wouldn't it?
I take the point, my lady.
All right. All right.
The final point that I would seek to make as to why I say he doesn't fall within that fifth criterion of unsuitability, and I'll deal with it briefly, given the time. His removal is prevented by virtue of the application of the Extradition Act 1989, which means that he cannot be removed during his sentence, and that's section 12, subsection 3A. However, under the current Extradition Act 2003, a court can consider a temporary removal or transfer and remove the prisoner to the requesting country, even whilst they continue to serve a sentence. And in my skeleton, I've said that as section 21B, which is the temporary transfer, but I'm grateful to my learned friend for pointing out it's also section 37 specifically. That is the removal provision.
Right.
Now, the Extradition Act 2003 came into force only a matter of months after the Portuguese extradition request was received by the Secretary of State. So, in my submission, it cannot realistically be said that the appellant's removal would undermine confidence when current statute would permit such removal.
But the current statute would permit removal to Portugal, not to Guinea Bissau. Is that right?
That is correct, my lady.
Well, the two things are rather different, aren't they?
Yes, but not insofar as they would both involve his removal from prison, and there would be a route out of his current ongoing and, in my submission, indefinite detention.
But who's to say, if he agreed to do some risk reduction work, that the parole board might not take a different view in the future?
The difficulty, my lady, is that there is unlikely to be a particular extent to which he can reduce his risk to such an extent that he does not pose a risk to the public.
Well, we just don't know, but the parole board said in their recent decision that these programs were available and he hadn't done them. Now, presumably they're saying that because they consider there's a possibility that he might be able to reduce his risk if he did that. I mean, the reality is we don't know. But you can't exclude, can you, the possibility that he'd reduce his risk if he did the work, can you?
In my submission, the risk that is perceived is such that even were he to undertake the one course that is available, the Kaizen course, which is available to individuals who do not accept guilt for the index offence, which is the appellant in this particular case.
Yeah.
That would not be sufficient, or highly unlikely to be sufficient, to reduce the level of risk that he is perceived as posing. High risk of serious harm to the public, medium risk to a known adult and child.
All right.
The final point in terms of unsuitability, and I highlight this briefly, is to say that these are not, these criteria lead to a specifically fact-sensitive case-by-case approach. It does not lead to automatic refusal. The categories are presented as being likely to be considered unsuitable, and if a prisoner falls within a category, will not usually be authorised. So clearly there are exceptions to the rule that even if a criterion is satisfied, it does not necessitate refusal.
All right.
Moving then, my lady, my lords, to the question of removability. And the respondents say that due to the extant extradition proceedings, he cannot be removed. And reliance is placed on the Immigration Directorate Instructions document, which is found at page 77 of the supplementary bundle. This policy sets out the approach to be taken to deportation under the automatic deportation route, which is to say the UK Borders Act 2007 route, or under the Immigration Act 1971, which is to say the test of whether or not removal is conducive to the public good. If I could draw your attention to page 82, section 2, subsection 4.5 in particular.
Yep.
Reliance is placed on that section, as it states, if a foreign criminal is subject to current extradition proceedings, they will be exempt from automatic deportation. Over the page, in an extradition case, the Judicial Cooperation Unit, or Metropolitan Police Extradition Unit, will contact the criminal casework case owner once an extradition request has been received. Any request for extradition from outside the UK takes precedence. Deportation must be put on hold while extradition is taken forward by the JCU. There are two key points that I seek to make in respect of that provision. First, I would invite your lordships to pay specific attention to the plain meaning of those words. It's not a term of art. The refusal or the placing deportation on hold is stipulated to be correct when there are current extradition proceedings and when extradition is being taken forward. In my submission, it cannot be said that extradition proceedings are current or being taken forward. The appellant,
They haven't come to an end.
they are static, my lord. They are suspended in the ether, and in the sense that there is no ongoing progress being made, I say that they cannot be said to be being taken forward. And in my submission, that will continue to be the case for the foreseeable future.
But isn't the first sentence of paragraph 2.4.5 simply a reflection of the statutory position of the UK Board of That?
Yes, my lord. The guidance.
So that's what current proceedings mean. It's just reflecting what the statute says. And the statute refers to the existence of a warrant or whatever the provision is. And there is one. That's how I read it anyway.
My lord, yes. The difficulty, though, is in relation to my lord, I'll take the point and I'll move on to my secondary submission. Even if the appellant does not fall within the automatic deportation route, he is nevertheless eligible for deportation under the Immigration Act 1971. And I would draw your attention...
I think the word is liable rather than eligible.
Liable to removal.
Eligible suggests that being deported is a good thing, but maybe it is in this case.
Forgive me, liable to
It's
removal.
a goal, a desideratum. All right.
Sections 2, subsection 3, at page 81.
Sorry, page 81. Sorry, I missed that reference.
Section 2, 3.
Section 2, 3.
Foreign criminals who do not meet the criteria for automatic deportation. That's what you're talking about.
If a foreign criminal does not meet the automatic deportation threshold, consideration must be given to whether deportation should be pursued under the Immigration Act 1971 because it would be conducive to the public good. Now, I've already taken the court through the relevant statutory provisions, but I just reiterate section 3, subsection 5A of the Immigration Act, taken together with section 32, subsection 4 of the UK Borders Act, set out that the appellant's removal as a foreign criminal would be conducive to the public good, and that is as a matter of statute. There is no discretion there.
Yeah, but all the policy is saying is you've got to think about whether or not to deport the prisoner because it would be conducive to the public good. It's not saying you have to deport them.
Well, my lady, there's no indication that the respondents have, in fact, followed through with that mandatory secondary step as part of this policy. In my submission, they have simply stopped short after considering the appellant is not removable, which in my submission is not correct.
I thought what they'd done was to apply a policy of prioritising extradition.
My lord,
That's the way they made the decision.
they have simply informed the appellant that he is not removable. In my submission, this policy requires a fact-sensitive analysis. It is not good enough to simply say, because of these extradition proceedings, he cannot be removed. The question is, bearing in mind the statute which sets out the fact that his removal would be conducive to the public good, whether in all of the circumstances he should be removed.
So does it come to this, that your point is that the statute, by saying that removing people subject to extradition is subject to the public, is conducive to the public good, means that you can't simply refuse to deport somebody merely because there's an extradition outstanding?
Yes, my lord.
You say they have to look at it, decide whether, in a particular case, on the particular circumstances, that's the answer.
Yes, my lord.
That's the point.
All right.
Those are all of the reasons why, in my submission, a correct reading of the statute and the policy point towards the appellant's liability for removal, his removability, and I say that he should be removed accordingly. A final point to make in respect of the first ground of appeal before I move to the second is that when one analyses the relevant case law where there are competing deportation and extradition proceedings, there is support to be found for my contention that extradition proceedings do not necessarily create a bar to removal, and the power to deport remains. And on that point, I would draw your attention to the two cases at tabs 1 and 2 of the bundle, the first being...
So that's Soblen and Cadu.
Yes, my lady.
Yeah.
And I've handed up the complete copies earlier this morning.
Yes.
Now, both of these cases concerned a foreign national in respect of whom there were competing extradition and deportation proceedings. And I'd like to draw your attention in particular to page 59 of Soblen, which is part of...
Did either case concern a person who was serving a sentence of imprisonment in the United Kingdom?
My lady, as far as I recall, no, the issues were immigration detention.
Right.
And neither case concerned the Extradition Act 1989.
Which page were you asking us to look at?
59, my lord.
259.
59.
Sorry, I think it's my fault. The two things, the two copies that were handed up loose this morning have got their own internal pagination, but aren't
Apologies,
paginated.
of course. It's
bundle
page
pagination.
301 of the judgment.
Right, thank you.
I'm most grateful. I do apologise for
No,
anything.
don't worry. So it's page 301 of the judgment in Soblen.
And it's halfway down the page. Lord Denning, Master of the Rolls, states, "It was suggested before us that there was a common law shackle on this power of deportation. It was said that a man could not be deported even to his own country if he was a criminal who had fled it. No authority was cited for this proposition. It cannot stand examination for one moment." And then at the very bottom of the page, and then over on to page 302, the power to deport is not taken away by the fact that he is a fugitive from the justice of his own country, or by the fact that his own country wants him back and has made a request for him. And the key principle is that so long as the deportation is carried out for an authorised purpose, then it is lawful. And I would invite the court to consider that in light of the appellant's circumstances.
This could be looked at as a much narrower decision. That there's no principle of law that you can't deport and thereby effect, in practice, an extradition for a non-extraditable crime, which was the issue in that case. You could see the argument if there's no treaty or need mechanism to achieve the same objective. I thought that's what that passage was really about.
The point, my lord, in my submission was that one cannot use deportation to frustrate the extradition safeguards that should be available. The court made it clear that deportation and extradition are distinct and separate, and the cause and effect are two different things. My learned friend would seek to distinguish these two cases, Soblen and Cadu, on the basis that the country requesting extradition is the same as the country to which the individual was deported. They are one and the same, France and America in the two cases. But I would say, whilst of course that is correct, it doesn't undermine the principle set out by Lord Denning, Master of the Rolls, because the cause and effect are entirely distinct. And as long as the deportation is carried out for a lawful purpose, then it cannot be interfered with.
If the principle in Soblen is that you can't use deportation to frustrate extradition safeguards, why has it got anything to do with this case?
My lord, because of the argument that is advanced by the respondents in terms of frustrating the extradition request.
That's the other way around, isn't it?
My lord, it serves to highlight that the two processes are distinct and must be considered separately. That is the point that I seek to emphasise.
Right, I can see that. Thank you.
So the basic point is two powers coexist, and the fact that there are extradition proceedings doesn't in and of itself mean that you can't exercise the power to deport.
My lady, yes. If the Secretary of State deemed the appellant's removal to be conducive to the public good and therefore deported him, that decision, in my submission, could not be interfered with because it were done for a lawful purpose.
All right.
The original ground of challenge that I think we're on is irrationality. Just trying to trace where we're going with this. It seems to have meandered off into a different ground of challenge from the one that was originally presented and the one that was decided on by the judge below.
My lord, it touches on the first and second grounds. So ground one was irrationality, ground two was a failure to follow published policy. And I raised this final point simply in terms of considerations given in the case law about competing deportation extradition arguments.
But I mean, the point here is that it's, as I understand it, the response have decided either applied a rigid policy that is wrong in law or something of that kind, which is a different point from the one that I was dealing with.
Well, my lord, the appellant's case is that it is irrational not to, in the appellant's circumstances, remove him, bearing in mind the suitability and removability points that I've taken you through. And that is what I say is irrational. If I may move to my second ground of appeal. This concerned the analysis of the parole board review. My submissions on this point are set out at paragraphs 67 to 69 of my skeleton argument. And I can take this more quickly than I took the first ground. Mr. Justice Baker, in refusing permission, stated at paragraphs 4 and 5 of his judgment, which is at page 42 of the core bundle, He stated that the parole board review was the key that unlocked what would otherwise be a logical puzzle for the claimant and prevents there from being a catch-22. He went on to say, if there is a difficulty in the claimant's case, it is in and about the parole board's decision not to authorise his release so far as the life sentence is concerned. In my submission, far from being the key that unlocks the puzzle, the parole board review is a key contributing factor to this catch-22, this logjam that the appellant finds himself in. And in those circumstances, I submit that the only real solution is the route via deportation. The test for release is one of a public risk assessment, and if it would assist the court, I can take you to the statutory provisions setting that test out.
I think we probably don't think we need to look at that. We've looked at it. Thank you.
Grateful. And that does include unproven allegations, and therefore we see in the parole board review, which I took the court to.
Sorry to interrupt. Maybe I should have looked at the provision. Does the provision itself refer to unproven allegations, or is that the parole board policy?
No, that is secondary to the statute. The statute simply says whether it is necessary for the protection of the public.
That's what I thought. So
yes.
So unproven allegations come in via some parole board policy. Is that right?
It's a policy, and it's been confirmed in the case law.
Okay.
This is a recent development in the policy following the high-profile challenges, I think. Am I wrong about that?
If I've set out in my skeletons the guidance document. If I could just have a moment, my lord.
Yeah.
Address this at paragraphs 23 and 24 of my skeleton, which is at page 116 of the core bundle. And I don't have these.
You don't have to delay any case.
I don't have the documents for the court, unfortunately, but it's set out in the guidance and confirmed in the case law.
But you're not suggesting that in this case they failed to follow the guidance or approached it in any.
I seek to submit that because they are bound to follow that guidance and take into account the outstanding allegations, therefore that is a contributing factor to the illogical nature of the appellant's circumstances.
But
that rather depends on how they're supposed to take it into account, or how they do take it into account.
yes, but the fact that we're required to take the allegations into account, unless the guidance tells them what weight to give to unproven allegations, doesn't tell you the extent to which unproven allegations will swing a particular decision, does it?
It's a case by case basis, my lady. Of course, a mere allegation would not be treated in the same way as an allegation that has supporting evidence.
But I mean, I think the point my Lord Justice Warby is getting at is that the mere fact that they're required to take something into account doesn't tell you anything about the likely conclusion in a particular case, because they may take unproven allegations into account and give them little weight compared with the index offence and the lack of risk-based work, if those are the facts. I mean, I'm not quite sure where this submission is leading.
My lady, I'll get to the point.
Yeah.
I've already taken you to the probation review, which I say sets out that the key risk factor is the outstanding allegations in Portugal.
Sorry, you mean the parole board decision?
Yes.
Yes,
Give me
sorry.
the parole board review.
Yeah.
And I say the key risk factor in that parole board review is the outstanding.
Yes, well, we've had your submissions on that.
Yes.
Okay.
And they will continue to loom large. There is no viable route in my submission that the appellant has in terms of reducing his perceived risk on that front.
But if you accept they'll continue to loom large, that must be because you accept they're relevant to risk, mustn't it?
Yes, my lady.
All right. Let me just get a note of that.
They are relevant to risk, but in these circumstances, it is illogical that the parole board review is contributing to the ongoing detention. And what I would highlight is the disconnect between the parole board's assessment in terms of risk to the public, as though the appellant were at large, compared to what will actually happen in reality if he were released, which is to be placed in immigration detention. And that is a key flaw in my submission.
But he wouldn't be in immigration detention indefinitely. He could only be in detention pending his removal somewhere else.
My lady, yes.
So that would be a short period before he's either extradited if he's been released by the parole board or removed if Secretary of State decides to remove him under the tariff expired removal scheme.
My lady, yes. That's
So the key issue is not what happens in immigration, what risk he poses in immigration detention, which is as it were, an in-transit position, but what risk he poses when he's eventually released into the world, whatever part of the world that is.
But my lady, were he to be released, which would then give rise to the consideration for the extradition request, he would most likely be detained in this country, removed, and then placed in detention in Portugal as well. So the assessment of risk based on his being at large is simply not relevant to the appellant's reality.
Why do you say he would be most likely go to Portugal? I don't really understand that.
The extradition request comes from Portugal.
Yes, I understand that.
And therefore, in the circumstances whereby the parole board deem him eligible for release...
No, I guess, sorry, forgive me, maybe I misunderstood you. I thought you were saying, the whole point is that they haven't deemed him for release.
No, they haven't.
I understand if they deemed him for release, then the next thing that would happen is that the extradition mechanism would take effect and either he'd be extradited to Portugal or not. And that I follow. I thought you were saying something different. Maybe you were.
Well, my lord, I'm seeking to emphasise what I say is the illogical nature of the parole board assessment in terms of this set of circumstances. The primary point in my submission is that he has no viable option to reducing his risk, and therefore there is a ongoing cycle between the outstanding allegations in Portugal and the parole board risk assessment, and one constantly leads to the other in my submission. My secondary point is to reinforce what I say is illogical about that cycle, and what in my submission would be an unending cycle, were it not for the route of removal by deportation. It is illogical that that cycle is brought about as a result of a risk assessment that is not logically tied to the appellant's real circumstances.
The bit I'm not understanding now, forgive me, is I think I had understood what you were saying about the parole board decision, but now you sound like you're trying to JR the parole board's decision here, and that's not what you're doing. So
No. Those are the points that I would seek to make in respect of the second ground.
Yep.
Moving then to the third ground, what I say is a failure to consider the arbitrary nature of the appellant's ongoing detention. It is well established that detention can be arbitrary, even if compliant with national law.
Yep.
And therefore I say, in my respectful submission, that Mr. Justice Baker stopped short and failed to go behind a consideration of merely whether the appellant's ongoing detention was compliant with national law. Now, of course, the appellant is detained subject to both extradition proceedings as well as the parole board review following a sentence by a competent court. So therefore, Article 5.1a and F are engaged. If I could draw your attention to two authorities, the first being at tab 3, Higilo and Cyprus, and the second one being at tab 6, James, Wells and Lee.
I mean, James was a rather different case, wasn't it? It was about imprisonment for public protection. And the problem there was that huge numbers of people had been given these sentences for relatively minor offences in the scale of things. They were sentences of indefinite detention. You had to convince the parole board it was safe to release you. And there were so many people subject to these sentences that they simply weren't getting the courses that would have enabled them to show that they were no longer a risk. It's a very different situation from the situation in this case, isn't it?
My lady, in my submission, it's somewhat different, but the link between the two would be that the ongoing detention in both cases is justified on the basis by reference to risk to the public and public protection grounds.
Yes.
And if I could turn you then to page 243 of the authorities bundle.
Sure.
Yep. Specifically, paragraph 189. Roughly halfway down, where it is stated, in short, there must be a sufficient causal connection between the conviction and the deprivation of liberty at issue. Jumping ahead slightly, in this connection, the court observes that with the passage of time, the link between the initial conviction and the deprivation of liberty gradually becomes less strong. Indeed, as the court has previously indicated, the causal link required by subparagraph A might eventually be broken if a position were reached in which a decision not to release or to redetain was based on grounds that were inconsistent with the objectives of the initial decision by the sentencing court, or on an assessment that was unreasonable in terms of those objectives. The court then went on to hold at paragraph 209, which is at page 252.
Yeah.
The court is therefore satisfied that in cases concerning indeterminate sentences of imprisonment for the protection of the public, a real opportunity for rehabilitation is a necessary element of any part of the detention, which is to be justified solely by reference to public protection.
Yeah, well, that's exactly the problem in that case, because the courses just weren't available. So they were being detained after the end of the tariff period for public protection purposes, but were unable to show to the parole board that they were safe because they couldn't go on any courses. This is a different case because the similarity is that the appellant is being detained beyond the end of his tariff for public protection, but he's being offered courses and he's just not taking them.
Well, my lady, in my submission, he is not being given a viable route with which to reduce that risk.
So this is back to your, sorry.
Yeah, no, after you.
Does this add anything to your point that, I mean, if you're right that the parole board review decision is based sufficiently on the allegations in Portugal to mean that it's you can't get out of it, then I understand what you're trying to say. But if you're not right about that, in other words, if there are other grounds for the parole board's decision which are open to being changed in future, then this doesn't add anything, does it?
No, my lord. This.
It's another way of putting the same point.
And if we assume that the parole board's decision is a lawful and rational decision about whether this individual meets the statutory criterion for release, doesn't that rather undermine both?
My lord, I think I would be bound to accept that it's something of an uphill struggle for me. But what I would say is that it's not simply a matter of looking at the parole board review. It's a matter of looking at all of the circumstances taken together, the extradition, parole board review, and the deportation, which produces this set of circumstances, which I say is irrational.
Right. Well, I think we've got your submission, and it rather depends on whether we accept your way of analysing it.
Yes, my lady.
All right. Okay.
In terms of that James Wells and Lee deals with the Article 5.1a issue.
Yeah.
Just before I move on from this ground, if I could direct your attention to the case of Higilo and Cyprus, and specifically...
Yes, sorry, that was my fault, because you were going to take us to that first, and I rather jumped in.
Well, this deals with the Article 5.1f issue.
Yeah.
And specifically at page 134.
Sorry, this paragraph 134.
Page 134.
Oh, page 134 of the bundle. Sorry, my fault.
It's paragraph 202.
Thank you.
It's stated, in addition to the requirement of lawfulness, Article 5.1 also requires that any deprivation of liberty should be in keeping with the purpose of protecting the individual from arbitrariness. It is a fundamental principle that no detention that is arbitrary can be compatible with Article 5.1, and the notion of arbitrariness extends beyond the lack of conformity with national law.
Yep.
Moving just back to paragraph 200, which is the page before, page 133. The penultimate line, final sentence, any deprivation of liberty under the second limb of Article 5.1f will be justified, however, only for as long as deportation or extradition proceedings are in progress. If such proceedings are not prosecuted with due diligence, the detention will cease to be permissible under Article 5(1)(f). Considering those principles and applying them to this case, in the appellant's particular circumstances, it is not possible to proceed with due diligence and remove the appellant expeditiously. I don't seek to repeat what I've already said, but
No.
his sentence is ongoing. He's not removable until released. And I say that's not going to happen for the foreseeable future. And my final point on that is that that is a key aspect of the arbitrariness.
But this applies to detention under Article 5(1)(f), and even if you're right about this point, you've still got 5(1)(a).
That's correct, my lady.
Yeah, okay. Thank you.
My lady, my lords, those are my submissions in respect of the grounds of appeal. Of course, there is also the application for a writ of habeas corpus. The appellant relies on the same submissions, the same arguments in respect of the judicial review claim as for the application for a writ. So I won't seek to revise or repeat the arguments that I've already put forward orally and in writing.
Yeah.
There remains then the issue as to whether or not the writ is available in the circumstances of this case. And of course, this was an issue that was raised by Lord Justice Dingemans when he was granting permission, which your lordship will find at page 133 of the core bundle.
Yeah.
My submissions are set out at paragraphs 45 to 54 of my skeleton, which is at page 123 of the core bundle.
Yeah.
And you'll note that I sought to set out two alternative arguments, but I don't seek to advance the secondary argument.
Right, let's just have a look at that.
So I would seek to focus solely on the primary sole argument, which is to say the remedy of a writ of habeas corpus is properly available in the appellant's circumstances.
There's authority that suggests if you're detained pursuant to an order of the court, habeas corpus doesn't run, isn't there?
Yes, my lady. The recent case law I recognise is somewhat point.
Well, I think didn't I can't remember if it was Mr. Justice Simon Brown at that stage or Lord Justice Simon Brown saying in one of the cases when he was sitting in the divisional court that at least one of the recent Court of Appeal authorities is not per incuriam because Armour and Guard cited in it, and there was a lot of citation authority, and the Court of Appeal reached that conclusion. So, I mean, to cut a long story short, aren't we bound by the two recent Court of Appeal cases?
My lady, you can depart from them if you consider that in light of Armour and Khawaja that they cannot stand.
Well, but that's why I was putting the point I just put to you, because if I can't, as I say, I can't remember if it was Lord Justice Simon Brown or Mr. Justice Simon Brown at that stage, having looked at it, thought that the argument that I can't remember which of the two Court of Appeal cases it was not per incuriam. Unless the Court of Appeal decision is per incuriam, we're bound by it, aren't we?
My lady, I take the point. I accept it's an uphill struggle for me.
Yeah,
to persuade you
I
otherwise.
think so. I mean,
right. Just briefly, my lady, I would seek to rely on Armour and Khawaja to support my contention that I've set out in my skeleton, that the writ of habeas corpus affords a broad scope of review, which I say is coextensive with judicial review. And to use Lord Wilberforce's term, it's a common principle.
Yeah. All right.
What difference does it make? That's the bit I haven't understood.
The difference is one of principle and also procedure, effectively.
Oh, I see. So you get this far without permission.
Permission is not required. That is correct.
Yeah.
Is that the only difference?
The discretion in terms of the judicial review is a key distinguishing feature. Of course, a writ issues as of right, and the remedies under judicial review are still discretionary. And that's, I've highlighted in my skeleton, is a key reason relied on by myself, but I adopt the reasoning of Professor Wade in his article, which is in the authorities bundle, as to justify that there shouldn't be a restriction of the review available under the writ of habeas
Yeah,
corpus.
but it all goes back to the point that I think we're bound by the more recent Court of Appeal authorities, and as I say, a fairly authoritative source has said they're not at least one of them is not per curiam. So I mean that's good enough for me.
My lady, I take the point. Unless there is anything further that your ladyship, lordships would like me to address you on.
Anything? No. All right. Well, thank you very much indeed, Miss Landry. That was very clear. Yes, Mr. Watson.
There are three essential features of the appellant's position, and draw some key characteristics of each. The three then are, firstly, that he's serving a sentence of life imprisonment, of course. He's post-tariff, tariff having expired on the 19th of August 2018. And his detention is, of course, now subject to the review by the parole board, subject to ground 2, but there has been no challenge to that decision of the parole board. This court, therefore, has to proceed on the basis that that was a lawful and rational decision, as already identified. Secondly, he is the subject of a valid extradition request issued by the government of Portugal. The request is proceeding under the Extradition Act 1989, with the appellant having been committed under Section 9 on the 14th of July 2004. And the 3 points I highlight on the extradition proceedings are, firstly, that the appellant's detention isn't therefore solely pursuant to the sentence of imprisonment, but also under the authority of the district judge. Secondly, of course, there is a statutory restriction under Section 12(3), which precludes any order for return being made while he is serving his sentence of imprisonment or detention until that sentence has been served, and there is and can be no criticism or challenge to that. And the third essential feature is of course, that he has no right to remain in the United Kingdom. Guinea Bissau national, whose asylum claim has been rejected, who's been served a notice of intention to deport. But there is, and this is the feature I would draw out here, there is in fact no deportation order that has been made against him. In my submission, that is an unpromising context in which to contend that any feature of his current detention is unlawful. And there is no proper basis in my submission to disturb the refusal of permission on the appellant's claim for judicial review, nor the decision to refuse his application for habeas corpus. Starting then with the judicial review claim, which, as formulated in the grounds, is that firstly there's a failure to proceed with deportation under terms which is irrational. Secondly, that failure to proceed is unlawful because of a failure to follow published policy. And thirdly, a failure to act with due diligence affecting removal, rendering detention arbitrary or disproportionate. Starting then with TERS, which goes to the heart of ground 1 of the appellant's appeal. and grounds 1 and 2 of the underlying claim. My submission is firstly that TERS sits in and is consistent with a broader context where precedence is given to extradition over deportation. That reflects what is, in my submission, an obvious public interest in giving such preference, even where, which is not the case here, even where removal under deportation or surrender under extradition would be to the same jurisdiction. The reasons are essentially, firstly, deportation even to the same jurisdiction risks undermining the extradition request because the individual will be returned with on a deportation basis, with no restrictions on their liberty. That's the point made in CADO, paragraph 11. And therefore, it risks the criminal proceedings even if returned to the same jurisdiction. Secondly, if deportation is done without reference to the extradition process, it would put the UK in breach of its international obligations in the extradition field to that jurisdiction. And thirdly, it's also right to recognise that, on the other hand, and this is the real issue underlying Sovereign and CADO, that deportation in those circumstances might lead to certain rights enjoyed by the extraditee, which should accompany his or her extradition, being lost, specifically the protection of specialty, which should require that in an extradition context you're only tried or sentenced for the offence specified in the request. And that protection is lost, therefore, if deportation takes place in a way that undermines the extradition process. All of those features apply, as I say, in circumstances where the extraditee or deportee would be surrendered or removed to the same jurisdiction, but they have an even greater force where one is dealing with the potential for deportation to a different jurisdiction from that which is seeking extradition, because it would have the effect necessarily of putting at risk the extradition process. Very obviously, in my submission, it would run contrary to international comity, which underpins extradition requests. 2, put the UK in direct breach of its international obligations in the extradition field. And as I say, 3, defeat the underlying criminal proceedings and certainly put them at grave risk in the extradition requesting state. All of that, in my submission, is to the obvious detriment of the public interest in prosecuting crime. So while my learned friend and the appellant is correct to note the public policy and public interest in removing those deemed not conducive to the public good, that sits in a hierarchy where precedence is given to extradition proceedings over immigration. And in my submission, that precedence is reflected properly in the Secretary of State's policies. The first being the Immigration Directorate instructions in the supplementary bundle, tab 6. And because it's important, could I just ask the court please to turn to it quickly? Supplementary bundle, tab 6, which is page 77. Starts at page 77. And paragraph 2.4.5. Which states in terms the policy that if a foreign criminal is subject to current extradition proceedings, they'll be exempt from automatic deportation, as my Lord Justice Warby noted earlier. That's reflecting the statutory provisions. And then over the page, in an extradition case, the JCU, the Met Police Extradition Unit, will contact the criminal case owner once an extradition request has been received. Any request for extradition from outside the UK takes precedence. Deportation must be put on hold while extradition is taken forward. It then continues, if extradition fails, JCU will tell the case owner who will proceed with deportation action. And in my submission, the reference to deportation must be put on hold while extradition is taken forward has to be read in the context of the alternative and its opposite, which is if extradition fails. Those are the circumstances in which deportation ought then to be taken forward. And what can't be said is that reference to extradition being taken forward requires, in practice, for there to be a series of ongoing extradition proceedings in the sense of extradition hearings taking place and or consideration being given by the Secretary of State to an authority to proceed, because there are circumstances in both old and new extradition statutes where extradition won't continue, the process won't continue, if, for example, an individual is charged with an offence in the United Kingdom.
I'm not familiar with extradition, but is there a process by which a much delayed extradition proceeding could be dismissed on the grounds of undue delay?
And, my lord, the answer to that question is I'm afraid it depends. It depends on the statute, it depends on the jurisdiction, and it depends on the circumstances. But I'll seek to explain. I'm not going to avoid it, just avoid the question by simply saying it depends. But it depends on these circumstances. Just to take the 1989 Act, the key obligation in terms of progressing expeditiously and where it's been relied upon by requested persons is at the very conclusion of the process. So once the order for extradition has been made, there's no further challenge to it. There is then an obligation to extradite within a specific period of time. If there's a failure to do that, that is a matter that can be challenged, and there's a series of authorities as to what amounts to a reasonable cause of delay, does administrative oversight count, etc. That is also reflected in the contemporary 2003 Act. 2003 Act has this additional feature to it, which is why I say it may depend on the jurisdiction. In a Part 1 case, which was enacted to give effect to the UK's then obligations under the European Union Framework Decision, the process proceeds on the basis of mutual recognition, and it's structured in that way. And therefore, this doesn't have a role in the process. So the warrant's received, it's certified by the NCA, and then the process continues. So in those circumstances, the Secretary of State doesn't have an option to withdraw the request because it's issued by a foreign body, prosecutorial court. Under Part 2 of the current Act, the position is as it was under the 1989 Act, which applies here, where the Secretary of State, it's accepted, has an outer limit of discretion to withdraw an extradition. And that's generally been held to apply in circumstances where, before amendments were made to the Extradition Act to prevent this, but where it was said human rights considerations have given rise to events that post-date the extradition hearing, and they ought now to be considered before extradition is actually given effect to. And the only mechanism for doing that is to bring the matter before the Secretary of State. The case of McKinnon was the one that really developed that jurisdiction, or at least underlined its existence. So, and I should say that ordinarily, though, issues of are matters being progressed expeditiously only arise in an extradition context at the very end of the process, when again there's an obligation to extradite within specific timeframes.
And I suppose in Part 1 cases, there's a whole lot of stuff about Article 8 rights and delay by the requesting state, but that's a different issue.
That's right.
Yeah.
And there is
actually the target of the extradition won't be complaining about being allowed to stay.
that's unusual. Yes, it's unusual. Though there are cases where people do, at the end of the process, just want to go. And equally, there is a statutory bar on the grounds of delay, but the focus of that is not the decision making here, but rather the delay in bringing the extradition proceedings themselves. I'm sorry, that's a rather long answer, but that's something of the position. But that's the framework, if I can put it that way, the policy framework set out in the Immigration Directorate instruction. And that's the context in which the TERS policy is then to be considered. So TERS is behind tab 3. This was the policy that applied at the time. It's in fact been repackaged under a generic parole process, but the contents of it are the same. But under this, under TERS,
Sorry, we haven't got tabs in our.
Oh, I'm so sorry. It's page 39.
Thank you very much. I should know it off by heart. Shouldn't I?
And the key feature, or one of the key features of TERS, and that's relevant here.
Sorry to interrupt. Can I just ask a question? It says it's issued in October 2013 and it expires on the 1st of May 2016.
Yes.
Did it in fact expire on the 1st of May 2016?
It didn't, and it remained operative until the 27th of January 2000.
Right.
The final decision taken in this case.
Sorry, 2020.
Sorry, 2020, I'm so sorry. Yeah, 2020.
Yes, sorry, I'm now getting very confused. So 27th of January 2020.
That's right, that's when
the
new
expired.
generic parole process came in, although it didn't affect any of the procedures. This TERS PSI was formally withdrawn.
Okay.
But as I say, it makes no difference to the issues here, and this was the PSI under which the appellant's case was considered.
Great, thank you.
Forgive me, Mr. Watson, what is a PSI?
Prison service instruction.
Thank you.
Sorry. The key feature, my lady and my lords, is that alongside the exemptions to removal under TERS, it is also a requirement within the PSI that the Immigration Enforcement Criminal Casework Unit has confirmed that there is no practical barrier to removal. And we'll see that both here and then in the guidance which follows, starts at page 61, tab 4. And that's, in my submission, for the obvious good reason that there is, if in fact there is a barrier to removal and the individual is not going to be subject to deportation, then of course there's no need to go through the consideration or the assessment of the criteria. If I could ask, and you'll see this throughout, but the most straightforward passages to take the court to are in paragraphs 3.6 and 3.8. So that's page 45. (3.8) sets out the criteria for refusal. At the bottom of page 45, if an IFNP is not presumed suitable to be removed under TERS on the grounds that one of the or more of the refusal criteria are met, and then this, or because CEC, that's the criminal casework within the Home Office Immigration Enforcement Unit, or CEC has confirmed that they are unable to remove the prisoner, the PP, which is CS, which is the Public Protection Casework section, must complete the TERS refusal form. Paragraph 3.6 in the middle, so middle of the page and in the middle of the paragraph. When you look at the way that the process works, and we'll see it in the guidance, it's for CC, that's criminal casework, to confirm whether an IFNP can or cannot be removed by completing the appropriate section of the pro forma. So it's clear that the refusal criteria sit alongside a question that is raised at the outset of the process as to whether there is in fact a barrier to removal. And if we then turn, tab 4 for those who are working on hard copies, and page 65 is the guidance. It begins on page 63. So it begins on page 61. Page 65, middle of the page. Reference to liabilities removal deportation, and then TERS does not affect an FNO's appeal rights against deportation, and then this removal from prison under TERS for deportation can only take place once there is a deportation order signed against the FNO and there are no outstanding appeals or other barriers to enforcing removal. Then there is the reference to the 5 exclusions, exemptions. If we turn through to the process, which begins on page 67.
So in other words, I'm so sorry, Mr. Watson. This policy says in terms that you can't remove somebody under TERS until there's been a deportation order.
That's right.
Right.
And we'll see how that works out, how that plays out in practice. Page 68. So under the heading process for TERS, page 67. Page page 68, it starts with this initial CC process. That's the initial criminal casework process. When a TERS case is referred to the Home Office, CC will decide whether the FNO is liable to deportation and whether deportation will be pursued.
Sorry, I'm being a bit slow. Page
Sorry.
68.
Page 68, top of the page. Initial CC process.
Oh, yes, thank you. Yeah.
And then over the page on 69, again consistent with that, PPCS will only commence the TERS consideration process. This is the beginning, top of the page, page 69. Only commence TERS consideration process once CC complete and return a TERS pro forma, confirming there are no barriers to removal. This will mean that the following will need to have been resolved. Bullet point 1. A deportation decision will have been served and deportation order will have been signed. So that's your gateway, if you like, to TERS consideration. And then just further down, at page 60, the same reference, where CC advised TERS information are currently barriers to enforcing removal, PPCS will not commence the TERS consideration process until CC confirm that either, bullet point 1, a deportation order has been attained and that there are no barriers to removal.
Sorry, again, I'm slightly behind.
I'm so sorry. Page 69 by the second hole punch,
Second hole.
where CC advised.
Oh, yes, got that. Thank you.
So does this mean, Mr. Watson, that the barriers to removal don't stop a deportation order necessarily being made?
Well, the
Well,
absence
there are
of...
two stages, aren't there? There's the notice of an intention to make a deportation order.
That's right.
That's the deportation decision.
That's right.
And then
But there is
deportation cannot be done until there's been a deportation order signed.
until
by the
deportation
Secretary of
order,
State.
that's right. And TERS only, you're only through the gateway into TERS if you have that deportation order.
And
Sorry.
can you remind me, Mr. Watson, where that sequence of decision making is set out? Because it's presumably in one of the immigration statutes, is it?
I don't think that this sequence, i.e. the TERS process, is set out.
No, not the TERS
sorry,
process. The
Giving notice of intention and then the
and then
deportation
serving
order.
the deportation order.
I'm afraid you're testing me.
No,
I'm
I
afraid
don't know
can't.
either.
Sorry.
Well, I'm sure I can find out.
Sorry.
All right.
But that is the
sequence.
That's the sequence.
Yeah.
And in reality here, it seems, but this is an aside and not a legal submission. In reality, it seems that it may be that the notice of intention to deport was given without recognising that there was in fact an extradition process that was also on foot.
Yeah.
I say that may be in the background.
It did look a bit as if one hand didn't know what the other was doing.
That's right.
But they're different offices or different...
They'll be within the Home Office, but they're quite different departments. Yes, and there is, to be very tedious about it, there is a form that is required to be filled in. It's an annex to a separate PSI, and one of the boxes is the individual subject to extradition. So there is a process that's designed to flag these issues up. But as I say, once you're through to TERS, then it's clear in my submission that is a gateway that you've got to get through.
Yeah.
Forgive me, Mr. Watson, but just reading TERS, I'm looking at page 69. The bullet point you referred us to, which was in the middle of the page, a deportation order has been obtained and that there are no barriers to removal. As I understand that in the context, it does mean that a deportation order might be obtained, an order, even if there are barriers to removal.
Yes, because I mean, you might, for example, have problems with getting an emergency travel document from the country that you're. I mean, that's a very common
That's
problem.
exactly right.
You
You may have a deportation order, but there's some other...
because people rarely have their original passports for some unknown reason, and so if they're going to be removed, there needs to be some form of travel document, and sometimes there can be difficulties getting those.
Exactly right, Manny. And the structure of this is to ensure that any such issues are ironed out before you look at TERS. And as I say, my submission is that all of that is entirely consistent with, when applied in an extradition case, all of that is entirely consistent with the precedents given to extradition for all the reasons that I identified at the outset. Here, then, the short point is that there is no deportation order the relevant passages in the correspondence, and I'm sorry the underlying materials are not in front of the court, but the relevant passages in the contemporaneous, so not the pre-action letter, but the contemporaneous decisions, are set out in the skeleton, my skeleton, at paragraph 17 and paragraph 19. So there's a letter dated the 2nd of August 2019, where it was said, Home Office Immigration Enforcement have confirmed that he's yet to be served with a deportation order. He's the subject of an extradition order which would exclude him from being considered for removal under TERS or deportation. And then paragraph 19, at this present juncture, deportation cannot be proceeded with due to extradition proceedings as such, cannot be considered for removal under TERS. PPCS will consider a case removal once they've received confirmation from their counterparts in Home Office Immigration Enforcement. There are no barriers to removal. And my respectful submission, all of that is entirely consistent with TERS and consistent with the broader policy context in which it sits. And I heard this morning, but I don't think it's been pleaded, that there may be a suggestion of some unlawful fetter that's been applied. But my respectful submission, there is no basis in statute to consider that the Secretary of State is constrained in such a way that she can't adopt a policy that gives priority to extradition over deportation. And indeed,
I think the submission was based on the facts of this case. If the Secretary of State had adopted a rigid policy of doing so regardless of any circumstance that might apply in the individual case, then that would be that may be a different point from the one
yes, and I think,
as well, but
and it's not quite pleaded because there's a wrinkle that if it were to be put, there is a slight wrinkle on this. In this case, the decision was taken not to proceed with deportation. That is not necessarily always the case, because there may be circumstances, and the pre-action letter refers to this, there may be circumstances where extradition can run alongside deportation. So you can extradite to the same jurisdiction you're deporting. You can therefore ensure that extradition retains its precedence because the individual goes back in custody under the warrant and the extradition process takes place. But that doesn't mean to say that the individual isn't also deported at the same time. And I understand, but only from the pre-action letter, there's a reference to TERS being available there, where you could interrupt an individual's, it's not this case, but you could interrupt an individual's sentence post-tariff under TERS to allow their extradition to proceed alongside their deportation. It's not this case, but that is at the bottom of the second part of that pre-action letter. So it isn't quite right to say that there's a rigid policy that's being applied, that no individual is ever deported. No individual is ever deported unless and until extradition proceedings are completed. The problem here is Section 12 of the Extradition Act, 1989, which precludes the extradition process from running until the sentence has been served.
once that's happened,
Once that's happened,
there may be simultaneous, in some circumstances there might be simultaneous.
under the 1989 Act, there might be. Here, there won't be, because deportation is to a different jurisdiction.
Yeah.
And the sentence can only be interrupted on TERS for the purposes of deportation. And as my learned friend pointed out this morning, there is, of course, provision now under the Extradition Act 2003 to permit temporary surrender of an individual for an extradition process who's serving a sentence, but with undertakings that they're returned back to the United Kingdom once the criminal proceedings in the foreign state have concluded. But as I say, none of that is available here because of Section 12.3, but there can be no proper challenge to Section 12.3. And, for reasons I'll come to under the parole board and ground 2, the claimant isn't caught in some terrible Kafkaesque situation where he's precluded from seeking release because of an extradition process, and he's precluded from being extradited because of the risks identified by the parole board. Those are not the facts of this case. But I think I've said what I need to about TERS and its relationship to extradition. I think I should only also flag this point, which is that, and it would only be relevant if the court were to grant permission and the case were to proceed, but to put this marker down, there might also be a question as to whether an individual could lawfully be deported while extradition proceedings, statutory extradition proceedings, were on foot. Because he's, of course, detained pursuant to the life sentence and detained under the Extradition Act 1989. And ordinarily, there is specific provision made if you're going to interrupt detention that is lawful under another statute. So, for example, the Extradition Act 2003 expressly states that a warrant of surrender to a foreign jurisdiction affords authority to the prison governor to release the individual to therefore transport. It's always tidied up, if I can use that phrase, to ensure that there's no ground for detention that hasn't been dealt with, or lawful basis for detention that hasn't been dealt with. And I query whether one could simply remove under TERS without also having to do something on under the Extradition Act. The answer might be that the Secretary of State would have to withdraw the authority to proceed and thereby end the extradition process. But something would have to be done in my submission to deal with that feature of his detention. Very briefly on the case law, in my respectful submission, Soblin stands for a narrow proposition that a deportation order in the face of a request for extradition to the same state will not be unlawful in circumstances where the purpose is genuinely deportation and it's not therefore a disguised extradition. And one can see in my submission immediately the concerns that would arise, particularly where, as in Soblin's case, it was a non-extradition crime. But I note, of course, Soblin wasn't a serving prisoner, immigration extradition to the same jurisdiction. And thirdly, in fact, there were no statutory extradition proceedings on foot in Soblin either. There'd been a request, but I don't think it got beyond that. And then CADU, tab 2 in the authorities, I don't think I need to take you there, but I refer to paragraph 11, and the reference is there to the powerful reasons of comity for giving priority to extradition, and the concern that if deported without notice to the French authorities, which would be normal practice, might well be deprived of the opportunity required to stand trial in France. So underlining paragraph 11, the proper basis for giving priority, as I say, to extradition over deportation. I think that is all that I need to say on TERS. I'm aware that there was a further and in any event reference to the appellant falling within the fifth exemption, but that wasn't in fact a basis upon which Mr. Justice Andrew Baker proceeded in the court below. You may remember that he in fact rejected that, or at least made no observations on it compared to.
I think he just
Justice
said
Friedman.
he'd prefer to say nothing about it.
Prefer to say nothing about it. And his having said nothing about it, I should say nothing about it.
All right.
On this appeal.
All right.
And it's right to say that that isn't the basis upon which the decisions were in fact taken in this case.
Yes, which is what why I registered a concern about it.
That's right.
And Sandra was making her submission.
Turning then, if I may, to ground 2 in the parole board. In my submission, Mr. Justice Andrew Baker was right to identify this as the key which unlocks the logical puzzle of the appellant's position. But the appellant is wrong to seek to characterise the parole board decision, which of course isn't under challenge here, as one where the key factor was were the outstanding allegations underlying the extradition request received from Portugal. If I could ask the court please to turn to the decision itself. Tab 14, the core bundle.
I think we've got tabs.
Sorry, let me give you a
I've got
page.
3 big tabs.
105. Sorry, 105.
Thank you.
And I know from this morning's discussion that the court will have the points already, but just to, if I may, just quickly draw out other features of this decision that don't turn on the Portuguese allegations. Starting page 106, just above the hole puncher, the second hole puncher, there is evidence to indicate clearly, and the reference there to mainly arising out of incidents in Portugal, but that isn't a reference to the extradition request.
Where are you now?
Page 106, middle of the page, analysis of offending. Clearly there was, and the detail of the first paragraph I'm not going to go to, but clearly there was material that went beyond simply the facts of the offence, but also went to the relationship between the appellant and his former wife. I want to draw out the fact that the incidents in Portugal can't be related to the extradition proceedings. But there is obviously a concern as to the appellant's approach to relationships and the risks that he thereby poses. Then on to page 107, of Mr. Ray. It's the third paragraph under the heading Evidence of Change Since Last Review and Progress in Custody, which begins, "You've not undertaken any offending behaviour work." And I just asked the court, or I rely on the last sentence, which begins, "Now that there are programmes available for those who deny their offences."
Yeah.
All witnesses, emphasise that, consider that risk could be reduced through your completing the motivation engagement programme, which may increase your suitability for the Kaizen programme. But then Mr. Ray, that's the prison offender manager, told the panel he discussed that with the appellant. "You're completely resistant. You continue to maintain that because your tariff expired, you're wrongly imprisoned." And then Ms. Hall's reference to features of the index offence, but also concern of an abscond risk, considering you previously breached immigration rules. I'm afraid I don't have details of that, but there must have been something underlying that assessment. And then over the page 108, middle paragraph between the two hole punches, "You said that you'd been willing to do programmes, that you had been willing to do programmes, but you are no longer in the, quote, right frame of mind, because you've been treated unjustly." And then Mr. Ralph, Community Offender Manager, this is page 108, last full paragraph. A reference there to the extradition request and the allegations there. But he went on. This is the third sentence. "Your denial of the murder was not the basis of his recommendations, as the Kaizen program can cope with that. Concerned, you deny all troublesome behaviour or any risks in relationships. Kaizen is a strengths-based course. He thinks it will help you to develop the skills you will need for future relationships." And then referring to manageability of risks in the community, Mr. Ralph said, this is all in the same paragraph, "You're required to disclose relationship, that this essential licence condition would not be sufficiently robust unless you had previously addressed your offending behaviour. You don't recognise you have any problems, unlikely that the programmes could be delivered in the community in view of the stance you've taken in prison." And of course, the reference to risks wherever you're released and not just released in the UK. It's against that background that Section 6 includes the panel's assessment of current risk. And I acknowledge, of course, that there is a reference there to the risks arising out of the allegations in the extradition request. But they are obviously not the key factor, as it was said earlier, because not least because one of the imminent risks identified is to future partners, which is irrelevant, and the extradition request is irrelevant, and the allegations in it are irrelevant to that request, to that risk. Ultimately, though, the key basis of the parole board's decision is, of course, in Section 8, conclusion and decision of the panel, which in its second sentence identifies, whilst your tariff has expired, your prison conduct is good, you've not completed any risk reduction work. Continued denial is not in itself an indicator of future risk, but the panel does not have any evidence to indicate your risks have lowered during your sentence, other than by the deterrent effect of the sentence itself. And therefore release not recommended, and indeed not even recommended for transfer to open conditions, which is the court will of course know, is often and ordinarily the process by which the parole board then test an individual to determine whether they have indeed demonstrated that their ongoing detention is no longer necessary for the protection of the public. So my respectful submission is that, firstly, it's wrong to characterise this as something of a catch-22 situation. Secondly, it's obvious in my submission from the parole board's decision that there is available to the appellant a key, practical key, to unlock the logical puzzle. There is no basis to suggest that this is in any way close to the situation where, as in Wales and others, it was said that individuals were being detained post-tariff or the equivalent in circumstances where they were precluded from access to courses that would enable them to demonstrate the reduction in risk. Very briefly, on the question of the parole board guidance, 2019 guidance on allegations, we don't have copies of it, but there'd be no surprises to the court that at paragraph 6 it refers to the parole board having to assess the relevance or weight of the allegations, and then either disregarding it, B, making findings of facts, or C, making an assessment of the allegation to decide whether and how to take it into account as part of the parole review. So, as one might anticipate, a flexible approach.
To be fair, it doesn't look as though that guidance was observed by the parole board in its decision in this case.
My lady, I don't have a brief for the parole board.
No.
And this court has to proceed on the basis.
Sure. No.
But no, and yes, as Mr. Justice Andrew Baker did, I don't make any comment on the parole board's decision.
But he did make a comment on the parole board's decision in the case that was cited by
in Delaney,
which was summarising that the board had proceeded on the basis that there were allegations, and that was enough to indicate that there was risk, and that was based on which he quashed the decision in that case.
That's right, my lord. And when I saw that, I wondered if that was perhaps one of the reasons why he referred to that particular feature of it in this decision.
Is it the same, Mr. Justice Baker? Mr. Justice Andrew Baker. It is Mr. Justice Andrew. Yeah. I was just wondering because there's scope for confusion.
There is quite a lot of confusion.
Yes.
No, that's interesting.
Yes, I thought it was an analogy with Lord Justice Dingerman's in the case of Jane. So my respectful submission is that on the facts, there is nothing in the parole board's decision that can advance the appellant's case here, and Mr. Justice Andrew Baker was right to find that there was no arguable basis to bring a judicial review claim on the ground too. Thirdly, Article 5, which I hope I can take very briefly indeed. My respectful submission is that given the parole board's decision and the absence of challenge to that, there is no proper basis on which to contend that the appellant's current detention is arbitrary. There is, under James, Walker and Lee, paragraph 189, a sufficient causal connection between the original reasons for detention and ongoing detention, and that is, in a sense, policed by the parole board. And on the facts, paragraph 209, there is, of course, a proper opportunity here for rehabilitation that has been identified, to the appellant. And in my submission, in fact, the Article 5 claim is really coterminous with the parole board challenge.
In fairness to the parole board, I think the passage that you took us to, in which Mr. Ralph's evidence was summarised, does show that he told them, and they took into account, the nature of the evidence that supported the allegations of mugging in Portugal, and that it included photographic fingerprinting. So it wasn't as if they simply approached it on the basis of what was alleged.
No.
Yeah.
No, but I think the key point is that the essence of their decision is the absence of risk reduction work about the index offence that's available to the appellant. And I don't think I need to say anything on Hegilo and Article 5.1f, given the clearly lawful basis for the detention under Article 5.1a pursuant to the sentence. And indeed, it's not uncommon for an extradition process to be held in abeyance in the sense that there's no ongoing extradition proceedings in terms of hearings, because, as I say, the process is interrupted by, for example, a criminal charge in this country. And there's never been any suggestion, there can't be any proper suggestion that while those processes continue, that the individual's detention is somehow arbitrary for 5.1f purposes, and certainly not here. And finally, I hope, habeas corpus. The short but complete answer to the appellant's claim is that he's lawfully detained pursuant to the sentence of imprisonment imposed on him following his conviction for murder. His submissions under the habeas corpus application are also only those, or the same as those, advanced under the judicial review claim. So the habeas corpus challenge can't take him any further. And given that this is an appeal against permission, my submission is it's an unpromising case in which to revisit the Court of Appeal decisions in Cheblak and Muboyayi, among others. And without wishing to get into the innards of that debate unnecessarily, I do note that the high watermark of the criticisms levelled at the decisions by Professor Wade are in a context where even he accepts that the proposition, this is page 443 of the authorities, tab 11, the proposition that habeas corpus should always be available to a prisoner who can show a legal flaw in his detention is admittedly subject to an ill-defined but important exception in the case of convictions by courts of competent jurisdiction. So even he acknowledges that where you have if the return to the writ would simply be, well, that's the conviction, and he's still serving, that would be the end of the matter.
Sorry, I've only just managed
Sorry.
to find page 443. Which paragraph, please?
It's sorry. It's at the bottom of the page from memory.
Oh yes, here we are. Got it. Last paragraph.
The last paragraph, that's right.
Yeah.
And although he refers to it as being an ill-defined but important exception, where there is a lack of definition, I don't think that it applies here in circumstances where there's no suggestion that the court wasn't competent to impose the sentence that it did.
Yeah.
And I think this is really only for completeness. I did notice that in Walker, in the House of Lords, this was before it went up to the European Court, and we have the decision in the bundles. There was passing reference by Lord Hope to the absence of availability of habeas corpus in circumstances where it's really a challenge to the parole board's decision. But I flagged the relevant passage in paragraph 5.
Oh, thank you.
I sent this to my one friend. 4.
Very much.
Thank you. And it's really at the top of the page. There's a reference to Lord Justice Simon Brown's decision in ex parte Corley that my lady was referring to earlier. And no suggestion from Lord Hope that the Court of Appeal has gone wrong in this line of decision, but also more direct relevance. This is sentences of imprisonment for public protection, I accept. There is no entitlement to release. This is at B,
Yeah.
top of page 591, until release has been directed by the parole board. and a direction to that effect cannot be given until the board is satisfied that detention is no longer necessary to protect the public. Mandatory orders may be obtained to ensure the system works properly, but it's not open to the courts to see that system set that system aside by directing release, contrary to the provisions of the statute. The introduction to that is Mr. Owen QC's submissions on their entitlement to a writ of habeas corpus, which is on paragraph 5, the other side of the page.
And was Lord Hope giving the judgment of the committee?
He agrees with the opinions of Lord Brown and Lord Judge CJ. But there's no...
I'm just trying to work out what the status of this observation is in a rather roundabout and
I don't think that I can say that it's part of the ratio of the decision.
right.
There's, and I'm not putting it on that basis. But
you're just saying
I simply say that it doesn't suggest
an authoritative dictum.
That's right. Strongly suggesting that habeas corpus shouldn't run where its effect would be to overtake or subvert, as we look at it, the decisions of the parole board.
Yeah. Okay. That's fine.
And in my submission, there is no proper basis to suggest, given the line of authorities, that the Young and Bristol aeroplane test is met, and that these are per incuriam decisions. As indeed Lord Justice Simon Brown identified in Muboyayi, Khawaja was expressly considered by Lord Wilberforce, that's page 486C to E, who distinguished it. So that's one of the two authorities that where it is said the Court of Appeal failed to take into consideration. That's Khawaja, expressly distinguished. And we know from the report that Amar was cited to the Court of Appeal in Muboyayi. And I, with respect, would also say that it's difficult to see how Amar and Ghana can stand as an authority now for the proposition that habeas corpus should range more freely than it does, because the context in Amar, and the habeas corpus challenge in Amar, was in fact one where the relevant Fugitive Offenders Act 1881 expressly provided at section 5 for the writ of habeas corpus as the basis on which to challenge the committal decision.
Well, that's quite important.
Fugitive Offenders Act 1881, section 5 concludes, where the magistrate commits the offender to prison, he shall inform the fugitive he will not be surrendered until the expiration of 15 days, and he has a right to apply for writ of habeas corpus or any other like process.
Oh.
And of course, if this court were interested in getting into the issue, my submission would be that both the criticism made both by the Law Commission and Professor Wade predate, and critically in my submission, the Human Rights Act and the availability of an Article 5 judicial review challenge. And of course, the fact that the procedures are now in place to ensure that in an urgent case, where there is a proper basis to claim Article 5 illegality, the Administrative Court Office is perfectly capable of ensuring that those issues are resolved expeditiously, urgently. So there isn't necessarily the need for the exercise of habeas corpus. But unless the court wants me to go further into those issues, that's all I intend to say on the habeas claim.
Do you want to hear any? No? No. All right. Thank you very much, Mr. Watson. Our appetite is sated. Thank you. Yes, Ms. Alligan, what would you like to say in reply?
My lady, just one brief point. You asked my learned friend a question in respect of the decision, the process by which the decision to make a deportation order is applied, and it may assist you to turn to page 88 of the supplementary bundle, which sets out some paragraphs in respect of the process.
Sorry.
It's part of the Immigration Director Instructions guidance document.
Needless to say, it's right at the bottom of the pile of bundles that I've accumulated. Right, page 88.
I only raise that just for the sake of trying to assist.
Oh, that's helpful. Yes, I'm still a bit curious about the statutory underpinning for the two stages. So what I might, I mean, we're going to reserve our decision. What I might ask is if the parties could just agree a note about the statutory underpinning for this two-stage process, please. That would be really helpful. If you could do it within 7 days, please, that would be really helpful.
Of course, ma'am.
Thank you very much. Good. Well, that's really helpful. Thank you very much. Would anyone either of you like to ask any further questions? No. Well, can I thank both of you for your very clear and helpful written and oral submissions. We're very grateful to both of you. We will reserve our decision, and judgments will come out in draft in the usual way. If you could, when they come out, if you see any typographical or other obvious errors, if you could let us know, please, but not disagreeing, not in disagreements with the substance. And then there'll be a handout by the remote protocol, so you won't be required to come to court. But if you could agree a draft order, please, that would be very helpful. And if there are any areas that you can't agree on, if you could send in written submissions, and we'll resolve any disputes on the papers. Good. Well, thank you very much, and thank you for your excellent time on it and for keeping to it. We'll rise.